10 seconds, 5 seconds. Start. Section 438 empowers the court to grant anticipatory bail. The necessity for granting anticipatory bail arises because sometimes intellectual persons try to implicate their rivals in false cases with a view to disgracing them or for other purposes by getting them detained in jail for some days. Apart from false cases where there are reasonable grounds for holding that a person accused of an offense is not likely to abscond or otherwise misuse his liberty while on bail, there seems no justification to require him first to submit to custody, remain in prison for some days, and then apply for bail. The term anticipatory bail is really a misnomer because what Section 438 contemplates is not anticipatory bail but merely an order releasing the accused on bail in the event of his arrest. It is manifest that there can be no question of bail unless a person is under detention or custody. Therefore, it is only on arrest that order granting anticipatory bail becomes operative. On the application of a person who has reason to believe that he may be arrested and that the arrest may be in respect of a non-bailable offense, the courts may direct that in the event of arrest, the person shall be released on bail. The court making such a direction may in its discretion impose conditions, including a condition that a person shall make himself available for interrogation by a police officer as and when required, and that the person shall not make any inducement, threat, or promise to any person for dissuading him for disclosing the facts of the case to the court or to the police, etc. If such a person, after getting the direction mentioned, is arrested without warrant by an officer in charge of a police station in respect of an offense to which the direction relates and is prepared to give bail, he shall be released on bail. If a magistrate taking cognizance of such an offense decides to issue a warrant of arrest against that person, he shall issue a bailable warrant in conformity with the direction referred to in section 438(1). The questions relating to anticipatory bail and interpretation of section 438 came up before the Supreme Court and the High Courts in several cases. The main conclusions that can be derived from these decisions may be summarized as follows. The power under section 438 being rather of an unusual nature, it is entrusted only to the higher echelons of judicial service, namely a court of session and the High Court, having jurisdiction over the local of the commission of the offense of which the person is accused. The place of residence or apprehension of arrest may not give jurisdiction. It is normally to be presumed that the court of session would be first approached for the grant of anticipatory bail unless an adequate case for not approaching the said court has been made out. It has also been held that it is not always necessary that the sessions judge should be approached first.